Wonderful. Thank you. Good afternoon, everybody. My name is Aravinda Kosaraju. I am a lecturer at the University of Kent, and I teach on an MA in Advanced Child Protection, which is a distance learning part-time course for practitioners in child protection. And my research over the years has been around child sexual exploitation and trafficking of children for sexual exploitation. Yesterday at the roundtable, I presented some ideas as to how the whole attrition process or lack of prosecutions is thought about both in practice and in policy. And today I was asked to kind of focus my talk on what is the kind of way forward. What do I have, if I have some suggestions in terms of practice and in terms of policy shifts. So I draw again from my own PhD research, which is submitted in 2018. So the data is slightly old. So apologies if that is found as a limitation, but let's hope some of the recommendations that have come from my research would be of use for practitioners and policymakers. And I'm going to borrow here, Mike, your phrase, the wheels of justice are not designed for current day problems. And I would like to start by saying that if I were to consider like the courts, the prosecution and police as three wheels, the society as the fourth wheel, there are lots and lots of what I would say hubs, spokes, cables, shafts that add to better transmission or running of the car or running of the wheel or the cart of justice. So today's recommendations, I'm going to focus mainly at the investigation stage and what the police said has been working for them in achieving effective investigations and getting.
I think we're losing you.
To take. Hello.
Yes, it's better now.
Can you hear me, Adelina?
Yes.
So I was just saying these recommendations, some of them are operational in nature and some of them are strategic. First and foremost, the police that work successfully in child sexual exploitation arenas said that we need to be making missing from home investigations integral to CSC investigations. Missing from obviously is a key indicator. It's quite significant in terms of the overlaps between missing and sexual exploitation, and making strong operational links can take us much forward. And this is particularly useful in early identification, in intelligence gathering, and in engaging victims. For instance, the value of written interviews where police conduct these interviews with specialist workers were highlighted many times in my research. Another recommendation is the need for a very bespoke victim engagement strategy. Lack of victims engagement was identified as a significant challenge by majority of the practitioners. Victims are the key to investigations and obviously to prosecutions, and hence looking after them, having a kind of a witness manager, having the investigators introduced to children early on, keeping them constant from the time a disclosure made to the end of the trial, so they can kind of work with the same investigator until everything is finished, and then keeping in touch with children and keeping them informed as to what is happening, managing their expectations as to what can come next and what the outcome might be, or how is it likely to pan out, and managing this process and supporting the key worker who establishes a relationship with the family, with the child, with parents, and also engaging mental health workers who can help deal with the trauma of not only of the abuse and exploitation, but also of the expected traumatic experiences that they may experience as they relive their experiences, trying to narrate what has happened to them. Another recommendation was around the need for as least disruptive as possible to the lives of children and families. For example, where computer.
We kind of lost you for a moment. Would you mind repeating the sentence from the beginning?
Disruptive approach to investigation families. For instance, where police take away computers and phones of children for investigation purposes and keep them. Children often perceive that as a form of punishment. Something has happened to me and I'm being punished and my phone has been taken away. So other practical things like, loss of phones, or sometimes children and families they're paying for the contract on the phones. There might be disruption to their school or learning because they might not be allowed to go to school. The perpetrators might be in the school, or abuse and exploitation might be related to school context. They might not be allowed to give exams. So all these small practical things need to be addressed as part of that support plan for the young person to engage them in a long term. Another vital aspect is allowing the young person to choose the medium of their statement. How do they want to make their statement or their narration or their narrative come into the courtroom? Obviously, video interviewing is seen as the most effective because the jury and the courts can see the effects and can see the value of what the child is saying. However, some of these children might have been videoed on camera, their abuse might have been videoed. So the very idea of being videoed for even for positive purposes can be traumatic for those children. So again, ensuring and asking those children how they want to present their story or their narrative is really important. And again, ensuring there's children find some sort of familiarity, and when giving their story, for example, using plainclothes officers or using places such as like a non-governmental organization's support service or a youth center to do these ABE interviews rather than in a police station. That makes children feel a bit more familiar rather than be traumatized by that experience. Again, another recommendation was going for non-standard achieving best evidence interviews. For example, often it was suggested that lack of child's understanding of the child's situation or being insensitive to questioning in AB interviews was very unhelpful. So some police officer chose to interview the child even on ABE along with a social worker or a youth worker who developed that kind of relationship with the child and was trained in ABE interviews, not rushing the interviews, going with the child's pace and allowing the space for the child to be confident to talk about their experiences. Again, one of the significant barriers that the police found was how do you tell the story of this child in their context, in what was happening to this child over time through ABE interviews. And one of the things that the police said, being inquisitive, even prior to engaging in ABE interviews, knowing the context of what has happened and probing a little bit more. If a child, for example, said, I consented to that sexual activity, again, asking bit more probing questions. What makes you think that you consented at that young age? And making the jury and the court understand that this child's understanding of what consent may not be what it should be or at the level what it should be. So it was suggested that, again, addressing delays. If a child discloses something and wanting to work with the police, getting in there as quickly as possible to engage with the child, not kind of going after a few weeks where the child might have changed her or his mind. Being very tactful about using risk orders. I talked about disruption tactics yesterday. Using these disruption civil orders to build on the intelligence rather than as a diversion technique, because police were concerned that, for instance, if an offender or a suspect has been given an abduction order, then following it up and building on that serving of abduction notices as evidence for a court trial later on. So using them as stepping stones towards investigation is really important. And also additionally, I mean, some things that relate to other organizations is like, I think this has been hampered in child protection arena. Multi-agency partnership working is extremely vital. It's not merely like developing a multi-agency safeguarding hub for exchanging information. Police were very keen about true multi-agency arrangements where there could be actually spaces, actionable spaces where they can share information, but also make dynamic risk assessments, because things change for these children very often in a very short span of time. So being aware of what is happening to the child, so those risks can be managed so the child don't disengage from the criminal justice process. Again, making sure there are like shared ethos amongst all practitioners, and through multi-agency practice and working, having those spaces for briefings and debriefings on a regular basis within those partnerships. And those were the kind of things that police were talking about. Of course, there are lots of challenges to that in terms of lack of policy on joint working, manifold systems and operations, lack of clear channels of communication, whatnot. However, when we say multi-agency partnership working in our policy, I think there needs to be more practical steps that could be taken at local authority and at force level that actually makes multi-agency partnership working possible. In addition to multi-agency partnerships, police also highlighted the importance of co-location. Co-location, they said, is the key because it promotes trust amongst the practitioners, and it's almost like trust is the first step to sharing information. It kind of deals with all those barriers, any myths that might surround in information sharing when it comes to protecting children. It optimizes the scope for effective information sharing and coordinated working. Co-located partnerships create that space for all those different partners to influence each other's responses, particularly amongst partner agencies. Simple things such as, for example, a young person worker might have said to their police colleague, we heard from a young person that they visited this area. It looks like a hotspot area. They kind of got a call from this person. He looks like a hot dot. So can we do something about it? Can we increase surveillance? And things like that. That kind of risk assessments were quite dynamic in places where there is that co-location happening. Again, like police also mentioned, we needed to look at this young person's Facebook and we didn't have the password. So we asked the parent support worker to work with the parent and get the password so we could kind of get some forensic intelligence together in relation to that particular case. Again, information sharing. So investigations don't kind of happen out of the blue. They need to build a problem profile in their local areas, and proactive approach is needed to identify those local patterns and potential suspects. So information sharing portals, although have been developed in many local authorities, such as the MASH teams, the police said the role they play, these portals may play, could be very much limited. Practitioners understood that it's creating, it's not just about creating protocols and portals, but it's about more actionable platforms. So it can be evaluated on a daily basis as to what have we agreed to act upon and who is acted upon and how is it panning out. So there's dynamism in our responses. Again, information sharing is not merely about sending a piece of information to the police or to other colleagues. It has to be clear, it has to be unambiguous, and also it has to be logically derived. So it's a practice of good, avoiding anecdotal references, but it's also the practice of good record keeping. So a lot of training is needed for particularly non-law enforcement colleagues. So things like that were kind of some of the things that were highlighted by the police. I'm happy to expand on some of the practical recommendations that have come up in relation to the Crown Prosecution Service in the discussion. Happy to answer any questions and take it from there.